Hello, good evening everyone. Welcome to Let's Crack UPSC CSE English in our crash course for Prelims 2021. Inspire will start with. Now today's lecture will continue with the fundamental rights. Yes. Welcome to Unacademy, India's largest e-learning platform, where you will get number of options to join Unacademy, where you will get daily life classes, structured courses, unlimited access for live and recorded classes, along with mock test, which is most important part throughout your preparation. We 100 plus top educators will guide you throughout your preparation. So download Unacademy learning app today and start your preparation. It's me, Rushikesh Inamdar, having experienced more than 8 years in the field of UPSC guiding and guidance, right? So you can join our Telegram group using this link, and you can follow me on Unacademy using this link. Yes. So those aspirants wants to start their preparation with modules. They have option to choose 15,000 plus courses like Polity, Governance, IR, History, Current Affairs, Geography, Indian Economy, and optional courses as well. Now, get your plus subscription now using referral code RBI Live to get 10% discount on your subscription. Yes, those candidates wants to start their preparation with our iconic subscription. They can opt iconic subscription, where you will get personal coach, study planner, and regular feedback. So start your preparation with iconic course, and again do not forget to use code RBI Live to get 10% discount. Yes, according to your convenience, you can join batches like 6-month batches, 1-year course, 2 years batch, NCERT batches, and many more. Yes, friends, you can join as per your convenience. So from 8 February onwards, we are going to start new batches. Yes, now you can enroll yourself for the Unacademy Combat as well, which is scheduled on 7th February morning 11 am. Now, this is information about our combo course, that is plus and iconic subscription, right? So use referral code RBI Live to get 10% discount. Yes, so now we'll start our today's topic series of fundamental rights. Okay, now already we have started Article 32. Okay, so friends, as you are now aware about what is meant by fundamental rights and their applications, so in today's lecture we'll see further details of fundamental rights. Now, as we have studied already Article 32, now under Article 32 the Supreme Court can issue the writs, and Article 226, just remember here relevance of Article 226, that is the High Courts can issue the writs. Okay, now we'll continue with our Article 32, means the Supreme Court can issue the writs. So before that, as we have described earlier, types of writs. So it's like habeas corpus, mandamus, prohibition, certiorari, quo warranto. These are the writs. mentioned in our constitution, right? So along with that, guys, here just note down for your reference, article 222 is also deals with the powers of high courts, that is issuing the writs. Now here, if we are talking about before 1950, only high courts of Calcutta, Bombay, Madras had the power to issue writs. Okay, so after that, Article 222 empowers all the high courts to issue the writs. Now it's easy to remember Article 32 and 226 as well. Okay, now basically, these writs are borrowed from English law, where they are known as prerogative writs. Okay, so these writs are borrowed from English law, right? So they are so called in England as they were issued in the exercise of the prerogative of the king, who was and is still described as the fountain of justice, right? Now in context of Britain, the same, later the High Court started issuing these writs as extraordinary remedies to uphold the rights and liberties of the British people. Just remember this historical background, that is, we borrowed these writs from British law. Alright, now come to India, and now the writ connections with our Indian constitution. So the writ jurisdiction of the Supreme Court differs from that of a High Court in three respects. As I told you, Article 32 and Article 226 deals with the writs powers of Supreme Court and High Courts respectively. Now we'll study the difference between, that is, writ jurisdiction, difference of writ jurisdiction between Supreme Court and High Court. So there are three clauses or three difference we can say. So like this, first difference is the Supreme Court can issue writs only for the enforcement of fundamental rights. Yes friends, just write down the point here. The Supreme Court can issue writs only for the enforcement of the fundamental rights, whereas a High Court can issue writs not only for enforcement of the fundamental rights but also other purposes, right? So here High Court can issue writs for the fundamental rights and other rights and other purposes as well, which means we can say in a single line, Supreme Court can issue writs only for the enforcement of fundamental rights, but High Court can issue writs for the enforcement of fundamental rights and ordinary legal rights. Okay, yes, if we are talking about Supreme Court, so they can issue writs only for the enforcement of fundamental rights. In case of High Courts, they can issue the writs for the enforcement of fundamental rights plus ordinary legal rights. Clear? Yes. Now, so in this respect, or with this first statement, we can say writ jurisdiction of the Supreme Court is narrower than the High Court. Remember this statement, guys. So maybe they will ask you in your statements, that is, writ jurisdiction of the Supreme Court in respect with the High Court is wider or narrower. So remember, writ jurisdiction of the Supreme Court in this respect is narrower than the High Court, because we assume always, like each and every cases, Supreme Court has maximum power. But if we are talking about jurisdiction of writ jurisdiction, it's narrower than the High Court. Clear? Now next, second is the Supreme Court can issue writs against a person or a government throughout the territory of India, right? Whereas a High Court can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only. Now, if we are talking about territorial jurisdiction, in this case, Supreme Court can issue writs against a person or government throughout the territory of India, while a High Court can issue writs against a person residing within its territorial jurisdiction. But if High Court wants to issue writ outside its territorial jurisdiction only if the cause of action arises within the territorial jurisdiction. Remember this point as well. Now, thus the territorial jurisdiction of Supreme Court for the purpose of issuing writs is wider than the High Court. Now here, if we are talking about writ jurisdiction in first respect, that is enforcement of fundamental rights and other rights, jurisdiction of Supreme Court is narrower than the High Court. But in second clause, that is Supreme Court can issue writs throughout the territory of India, means territorial jurisdiction of the Supreme Court issuing writs is wider than of a High Court, right? Now next, third, a remedy under Article 32 is in itself a fundamental right, and hence the Supreme Court may not refuse to exercise its writ jurisdiction. So basically, writ jurisdiction of Supreme Court differs that from the High Court in three respects. In first, writ jurisdiction of the Supreme Court is narrower than the High Court in respect of enforcement of the fundamental rights and other legal rights. In second clause, about territorial jurisdiction of Supreme Court is wider than the High Court, okay, than of a High Court. And now third, a remedy under Article 32 is in itself a fundamental right, and hence the Supreme Court may not refuse to exercise the writ's jurisdiction. Right, now we'll see in the case of High Court what happened here. Article 226 deals with this writ powers of the High Court, where Article 226 is discretionary, means High Court may refuse to exercise its writ jurisdiction. Alright, so here is the difference between Article 32 and Article 226. Just write down this difference. So Article 32, it's itself a fundamental right, and Article 226 is discretionary power of the High Court. Right, now next, Article 32 does not merely confer power on the Supreme Court, as Article 226 does on a High Court to issue writs for the enforcement of fundamental rights or other rights as part of its general jurisdiction. Right. Now, the Supreme Court is thus constituted as a defender and guarantor of the fundamental rights. Yes. Now, after these conclusions and few details, we can say that the Supreme Court is constituted as a defender and guarantor of the fundamental rights. Now, we'll proceed to understand the meaning and scope of different kinds of writs mentioned in the Article 22 and 226 of the Constitution. So, as I told you earlier, the types of writs were first is habeas corpus, second mandamus, third certiorari, fourth prohibition, and fifth quo warranto. Now, we'll start with habeas corpus. Yes. So, habeas corpus means powerful. Alright. So, this writ is more powerful and mostly usable. Right. So, these are the Latin words where habeas corpus means to have the body of. Alright. So, habeas corpus means to have the body of. So, it is an order issued by the court to a person who has detained another person to produce the body of the letter before it. Okay, so it means the court then basically court can issue order. Okay, so basically this writ is an order issued by the court to a person who has detained another person to produce the body of the letter before it. Okay, now in this case the court then examines the cause and legality of detention. We should understand the line is that the court then examines the cause and legality of detention. Right. Now, it would set the detained person free if the detention is found to be illegal. In this case, court can issue the order to release that person from detention. Okay, so we can say this writ is a bulwark of individual liberty against arbitrary detention. Alright, now the writ of habeas corpus can be issued against both public authorities as well as private individuals. Right, now the writ on the other hand, so if we are talking about habeas corpus, this writ is not issued where detention is lawful. Second, the proceeding is for contempt of a legislature or a court. Third, detention is by a competent court. And fourth, detention is outside the jurisdiction of the court. So, remember these four clauses where this writ cannot be issued. Okay. So, habeas corpus is not issued in the case of where detention is lawful, the proceeding is for contempt of a legislature or a court. Next, detention is by a contempt court, detention is by a competent court and detention is outside the jurisdiction of the court. Right. Now, if we are talking about this writ, and we'll see one case, that is Rudul Shah versus State of Bihar. In that case, habeas corpus writ was issued. Okay, now in that case, what happened? Rudul Shah versus State of Bihar, in which a person who has already detained or who already completed his period of detention and was still kept in prison for extra 14 years. What happened? A person who had already completed his period of detention and was still kept in prison for an extra 14 years. In that case, habeas corpus writ was issued. Okay, so remember this important case related with the habeas corpus. I hope you understand the scenario of first writ habeas corpus. Yes, now we'll move to the next writ, that is mandamus. Yes, mandamus means we command. So it is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. So mandamus means we command and is a command issued by the court to a public official asking him to perform his official duties. Alright. Now, it can also be issued against any public body, a corporation, an inferior court, or a tribunal, and government also for the same purpose. Alright, so this is the scope of this writ, or we can say the writ of mandamus can also be issued against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. Now next, the writ of mandamus cannot be issued against a private individual or body to enforce departmental instruction that does not possess statutory force. So now remember these points where this writ cannot be issued. When the duty is discretionary and not mandatory. Next, this writ cannot be issued in case of to enforce a contractual obligation and against the President of India or the state governors and against the Chief Justice of a High Court acting in judicial capacity. Right. So, these are the few exceptions where writ of mandamus cannot be issued. Right. So, we can say there is one famous case, that is Gujarat State Financial Corporation versus Lotus Hotels. Right. What happened in that case? So, Gujarat State Financial Corporation had an agreement with the Lotus Hotel where that agreement in which they mentioned that this authority, that is Gujarat State Financial Corporation, will release the funds so that Lotus Hotel can complete their construction work. But later on, that financial corporation denied or refused to release the fund. Okay, so then in that case, this writ of mandamus was issued. Alright. Now next. Next, prohibition. Yes. So prohibition means to forbid. Now, remember, we'll see the difference between prohibition and certiorari, right? So prohibition means to forbid. So it is issued by a higher court to a lower court or a tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Alright, so we can say this is a preventive action. In simple words, we can say it's a preventive action. So, thus, unlike mandamus that directs activity, the prohibition directs inactivity. So, the writ of prohibition can be issued only against judicial and quasi-judicial authorities. Alright, now, so it is not available against administrative authorities, legislative bodies, and private individuals or bodies, right? So this writ, or we can say this cannot be issued against administrative authorities, legislative bodies, and private bodies, right? Now, so here we can say, if before the judgment is announced, if you want to take, then you can use the writ of prohibition. All right. Now, so there is one famous quote we can say. So we can study, that is, prevention is better than cure. Okay, so cure, we can say cure is related with the certiorari writ and prevention is deals with the prohibition. Now we'll see certiorari. So it means to be certified or to be informed, right? So it is issued by a higher court to a lower court or tribunal, either to transfer a case pending with the latter to itself or to squash the order of the latter in a case. So it is issued certiorari, it is issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. Alright. So unlike prohibition, which is only preventive, and certiorari is both preventive as well as curative. Okay, now previously the writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. But what happened in 1991? The Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting rights of individuals. Okay, so like prohibition, certiorari is also not available against legislative bodies and private individuals or bodies, right? Yes, just remember these points related with the certiorari. Yes, next is quo warranto. Yes guys, last read, that is quo warranto, where it means by what authority or warrant. Yes. Yes, guys. So, co-warrantor. Now, it means, okay, you want to write down few topics. Yes, sir, sure. So, just write down the topics. Few points. Yes. Now, co-warrantor. So, it means by what authority or warrant. So, it is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal aspersion of public office by a person. Right. So, the writ can be issued only in case of substantive public office of a permanent character created by a statute or by the constitution. It means co-warrantor writ cannot be issued in cases of ministerial office or private office. Just remember these points. Yes, co-warrantor means by what authority or warrant, and this writ issued by the court to inquire into the legality of claim of person to a public office. Right. Now, next. After these writs, will start our next article, that is armed forces and fundamental rights. Yes, guys. Here, Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. Yes. So, we'll see the relation with the armed forces and these fundamental rights. Yes. Right. So, Article 33 deals with empowerment or empowers the our parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. So, the objective of the provision is to ensure the proper discharge of their duties and the maintenance of discipline among them. Right. So, objective of this is to provision to ensure the proper discharge of their duties and the maintenance of discipline among them. All right. Now, the power to make laws under Article 33 is conferred only on Parliament and not on state legislatures. Yes. Here, just write down the point. The power to make laws under Article 33 is conferred only on Parliament and not on state legislatures. Yes. Now, next. Any such law made by Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights, which means any such law made by under Article 33 cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Yes, so in simple words, layman words, we can say that Article 33 is ensure that limitations of armed paramilitary police forces and intelligence agencies to perform or to enjoy fundamental rights. So there are restrictions with them to perform their duties and maintenance of discipline. Alright, next. So in this article we can say Parliament has enacted few laws like the Army Act 1950, the Navy Act 1950, the Air Force Act 1950, Police Forces Restrictions of Rights Act 1966, Border Security Force Act, and so on. So these are the acts enacted under this article by our Parliament. So this impose restrictions on their freedom of speech, right to association, right to be member of trade unions or political associations, right to communicate with the press, right to attend public meetings or demonstrations, etc. So we can say these acts imposes restrictions on their freedom of speech, right to form association, right to be member of trade unions or political associations, right to communicate with the press, and right to attend public meetings or demonstrations. Yes, just write down these points. Next, martial law and fundamental rights. After Article 33, now we'll start with the next Article 34 provides for the restrictions. Article 34 provides for the restrictions on fundamental rights, while martial law is in force in any area within the territory of India. Yes, it empowers the Parliament to indemnify any government servant or any other person for any act done by him in connection with the maintenance or restoration of order in any area where martial laws was in force. Right. So the Parliament can also validate any sentence passed, punishment inflicted, forfeiture orders ordered, or other act done under martial law in such area. So basically Article 34 provides the restrictions on fundamental rights, while martial law is in force in any area within the territory of India. Alright, next. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. So the concept of martial law has been borrowed in India from the English common law. Again, the concept of martial law has been borrowed in India from the English common law. Yes. So we can here just remember that the expression martial law has not been defined anywhere in the Constitution. Alright. So it means military rule. Martial law means military rule. So The martial law, military rule, is imposed under the extraordinary circumstances like war, invention, insurrection, rebellion, riot, or any violent resistance to law. Alright. So, we can say during the martial law or operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. Now, we can say they impose, means this military rule impose restrictions and regulations on the rights of the civilians, can punish the civilians and even condemn them to death. And the Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. So the declaration of martial law under Article 34 is different from the declaration of a national emergency under Article 352. Yes guys, just remember the difference and the points related with the Article 34 and Article 352 here. Okay. So the declaration of martial law or military rule under Article 34 is different from the declaration of national emergency under Article 352. Yes, next. Now we'll see the difference between martial law, that is military rule, versus national emergency. Yes. So here, now we'll see there are few points related with that is difference between that martial military rule versus national emergency. So martial law affects only fundamental rights and national emergency affects not only fundamental rights but also center-state relations, distribution of revenues and legislative powers between center and states, and may extend the tenure of the parliament. So this is the first difference between martial law and national emergency. In martial law or military rule suspends the government and ordinary law courts, where national emergency continues the government and ordinary law courts. Okay. Yes. Now, martial law is imposed to restore the breakdown of law and order due to any reason, whereas national emergency can be imposed only on three grounds, that is war, external aggression, or armed rebellion. All right. Yes. Now next, military rule means martial law is imposed in some specific area of the country, where national emergency is imposed either in the whole country or in any part of it. All right. Now next, martial law, it has no specific provision in the constitution, it is implicit, whereas national emergency has specific and detailed provision in the constitution, which means it is explicit. Yes. Next, affecting certain fundamental rights. Yes guys, so here Article 35. Now after Article 34 will start. Next, Article 35. Yes. So Article 35 lays down that the power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state legislatures. So here Article 35 mentioned that power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament. Alright, now this provision ensures that there is uniformity throughout the India with regard to the nature of those fundamental rights and punishment for their infringement. So in this direction, Article 35 contains the following provisions. First, the Parliament shall have and the legislature of a state shall not have power to make laws with respect to the following matters. Alright, so now we'll see few provisions related with the Article 35 where the Parliament shall have power to make laws with respect to following matters where first, prescribing residence as a condition for the certain employments or appointments in a state or union territory or local authority or other authority described in Article 16. Right. Next provision. Empowering courts other than the Supreme Court and the High Court to issue directions, orders and writs of all kinds of the enforcement of fundamental rights mentioned in the Article 34. So here we are just studying Article 35 related with the powers of the Parliament to make laws. Next, third provision. Yes. Third provision, restricting or abrogating the application of fundamental rights to members of armed forces, police forces, etc. under Article 33. And next provision, indemnifying any government servant or any other person for any act done during the operation of martial law in any area, that is Article 34. Alright, so these are the provisions related with the Article 35. Now next, Parliament shall have powers to make laws of prescribing punishment for those acts that are declared to be offences under the fundamental rights. Yes. Now, Parliament shall have, the legislature of a state shall not have. So the Parliament shall have powers to make laws for prescribing punishment for those acts that are declared to be offences under the fundamental rights, which includes untouchability described in Article 17 and traffic in human beings and forced labor mentioned in Article 23. Alright, so the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishment for the above acts, thus making it obligatory on the part of the Parliament to enact such laws. Alright, now, next provision, that any law enforced at the commencement of the Constitution with respect to any of the matters specified above is continue in force until altered or repealed or amended by the Parliament. Yes. So here it should be noted that Article 35 extends the competence of the Parliament to make a law on the matter specified above, even though some of those matters may fall within the sphere of the state legislature, that is state list. Alright, now, yes, any doubt, guys? So just remember these points. Now, next is exceptions to fundamental rights. So first is saving of laws providing for acquisition of estates, etc., which describes as Article 31A, saves 5 categories of law from being challenged and invalidated on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, and Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. So we'll study few exceptions to fundamental rights, where first is saving of laws providing for acquisition of estates, etc. So basically they are related with the agricultural land reforms, industry and commerce, and include the following, like acquisition of estates and related rights by the states, taking over the management of properties by the state, amalgamation of corporations, extinguishment or modification of rights of directors or shareholders or corporations, and extinguishment of or modification of mining leases. Alright, so Article 31 does not immunize a state law from judicial review unless it has been reserved for the President's consideration and has received his assent. So this article also provides the payment of compensation at market value when the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limit. Okay, so this is the first clause related with the exceptions to fundamental rights. Next, validation of certain acts and regulations mentioned under Article 31B. These are the exceptions to the fundamental rights. First is saving of laws providing for acquisition of estates. Second, validation of certain acts and regulations, where we can say, yes, so Article 31B saves the acts and regulations included in 9th schedule from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Okay, so we can say the scope of Article 31B is wider than the Article 31A. Okay, so Article 31B immunizes any law included the 9th schedule from all the fundamental rights, whether or not the law falls under any of the 5 categories specified in Article 31A. Okay, so the court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the 9th schedule. So it said that the laws placed under the 9th schedule after April 24, 1973 are open to challenge in court if they violated fundamental rights guaranteed under Article 14, Article 15, 19 and 21, or the basic structure of the constitution, right? So 24 April 1973, it means it was on 24th April 1973 the Supreme Court first propounded the doctrine of basic structure or basic features of the constitution in its landmark verdict in the Keshwananda Bharati case. Alright, now next exception. Third, saving of laws giving effect to certain directive principles. Yes, so Article 31C, as inserted by the 25th Amendment of 1971. Alright, so following we can study two provisions related with the Article 31C, which is no law can be or no law that seeks to implement the socialist directive principles specified in Article 39B, 21 or C22 shall be void on the ground of contravention of the fundamental rights conferred by Article 14, that is equality before law and equal protection of laws, or Article 19, protection of Sikhs' rights in respect of speech, assembly, movement, etc. Alright, next, no law containing a declaration that is giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. Alright, so these are the three exceptions for fundamental rights, that is saving of laws providing for acquisition of estates mentioned in Article 31A. Next, validation of certain acts and regulations mentioned in Article 31B, and saving of laws giving effect to certain directive principles mentioned in Article 31C. Alright, now next, significance of fundamental rights. Yes guys, the fundamental rights are significant in following respects. Yes, so they constitute the bedrock of democratic system in our country. Next, they provide necessary conditions for the material and moral protection of man. They serve as a formidable bulwark of individual liberty. They facilitate the establishment of rule of law in the country. They protect the interest of minorities and weaker sections of society. They strengthen the secular fabric of the Indian state. They check the absoluteness of the authority of the government. They lay down the foundation stone of social equality and social justice. They ensure the dignity and respect of individuals. Yes, and they facilitate the participation of people in the political and administrative process. So these are the points to be remembered in relates with the significance of fundamental rights. Yes friends, next, rights outside part 3. Besides the fundamental rights included in part 3, there are certain other rights contained in other parts of the constitution. So these rights are known as constitutional rights or legal rights, and which means non-fundamental rights, like no tax shall be levied or collected except authority of law mentioned in the Article 265 in part 12. Next, no person shall be deprived of his property save by authority of law. Article 300A in part 12. Next, trade, commerce and intercourse throughout the territory of India shall be free, which is mentioned in Article 301 in part 13. So, even though above rights are also equally justiciable and they are different from the fundamental rights. So, in case of violation of the fundamental right, the aggrieved person can directly move the Supreme Court for its enforcement under Article 32, which is in itself a fundamental right. And in case of violation of above rights, that is non-fundamental rights, the aggrieved person cannot avail the constitutional remedy. So he can move the High Court by an ordinary suit or under Article 226, writ jurisdiction of High Court. So, dear friends, it's all about fundamental rights. So we have covered into the part 1, 2, 3, 4, 5. One of the important chapter related with her prelims and mains examination. Alright. So keep revising the part now. We'll see at the end of the lecture, we'll see articles related to fundamental rights at a glance. Okay. So here first is general. Article 12 definition of state. Article 13 relates with the law inconsistent or with or in derogation of the fundamental rights. Now next, right to equality. Under this fundamental right, we have studied Article 14, that is equality before law. Article 15, prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 16, equality of opportunity in matters of public employment. Article 17, abolition of untouchability. Article 18, abolition of titles. Under the heading of right to freedom, we have studied Article 19, protection of certain rights regarding freedom of speech. Article 20, protection in respect of conviction for offences. Article 21, protection of life and personal liberty. Article 21A, right to education. Article 22, protection against arrest and detention in certain cases. Under the heading of right against exploitation, where we have studied Article 23, prohibition of traffic in human beings and forced labor. Article 24, prohibition of employment of children in factories. Under the heading right to freedom of religion, we have studied Article 25, that is freedom of conscience and free profession, practice and propagation of religion. Article 26, freedom to manage religious affairs. Article 27, freedom as to payment of taxes for promotion of any particular religion. Article 28, freedom as to attendance at religious instruction or religious worship in certain educational institutions. Next is under the heading cultural and educational rights, we have studied Article 29, protection of interest of minorities. Article 30 describes right of minorities to establish and administer educational institutions. Under the heading right to constitutional remedies, we have studied Article 32, which describes remedies for enforcement of rights conferred by this part. Article 32A, constitutional validity of state laws not to be considered in proceedings under Article 32, which was repealed. Article 33 relates or describes power of Parliament to modify the rights conferred by this part in their application to forces and Article 34 related with the restrictions on rights conferred by this part while martial law is in force in any area. Next article, last one is Article 35, legislation to give effect to the provision of this part. So, yes friends, so we have studied all fundamental rights in these lectures. So, keep revising all these topics and do not forget to enroll for our Unacademy Combat scheduled on 7th February 2021 in the morning 11 am. Alright guys, so like, share and subscribe our channel and videos. Do not forget to use referral code RBI Live to get 10% discount. Join our Telegram channel through this link to get daily updates related with current affairs and preparation strategy. And also you can hit the bell icon for notifications of our lectures. So guys, in this crash course we have started polity and where we have completed fundamental rights. Now we'll see you tomorrow in the next lecture of polity. Till the time, keep studying, keep revising and continue with your doubts. If anybody facing any challenges in their preparation, they can ask doubts. Alright. Yes, so that's it for the day. Keep revising, keep studying. All the best.